Hey there, welcome back to my channel. I'm Shep the Lawyer, and on this channel we talk about past and present celebrity lawsuits that business owners can learn from. Today we are talking about a copyright infringement lawsuit. Two Detroit rappers, they are filing this lawsuit, or they filed this lawsuit against rappers Big Sean and Megan Thee Stallion. So Big Sean and Megan Thee Stallion are pretty big mainstream rappers. They created this song called Go Crazy. I believe it came out in 2020. And these other two artists who are not as big as Megan Thee Stallion and Big Sean are saying that Megan Thee Stallion and Big Sean completely copied their song, which their song is called Crazy. Now, I listened to both of the songs, and I will tell you guys that I don't know, it's similar. The thing that's similar to me mainly is the chorus, but at the same time, in the song they're saying go crazy. Like both of the songs are saying like something about go crazy. And I think that that's a common phrase. So I'm from the Bay Area, Oakland, California, originally. I live in Texas now, and like go crazy, like that's just a term that's been around for a long time. So that part is kind of like, I don't know. But if you really listen to like the tempo, I guess I can kind of see it. I don't want to admit it, but I don't know. So you guys should go on YouTube and look up Big Sean and Megan Thee Stallion, Go Crazy, and then look up, what are their rap names? Look up Go Hard Major and H-Matic. So H-Matic is H-M-A-T-I-C, and then Go Hard Major, and their song is called Crazy. So look up Go Hard Major Crazy, and then, or Go Hard Major and H-Matic Crazy. Those are the other two rappers' names. So look it up, y'all. Listen to it and tell me in the comments if you think the songs are similar, because I don't know. Okay, so of course we're gonna go through the complaint. We're gonna read the lawsuit. I didn't want this video to be extremely long, so I pretty much pulled out the important stuff to go over with you guys, but it's basically most of the lawsuit. So we're gonna go over that. I'm gonna give you kind of my reaction to the lawsuit, what I think, my thoughts as always, and then at the end, we should pull out a lesson for you guys, like I always try to do. Okay, so we're gonna start off, oh, let me tell you guys who's being sued, huh? So the two artists that are suing, their government names are Dwayne Payne and Harrell James, and like I said, their rap names are Go Hard Major and H-Matic. I hope I'm saying H-Matic right, but that's what it looks like it says. So those two people are suing quite a few entities, as well as Megan Thee Stallion and Big Sean. So they're suing Theory Entertainment LLC, 1501 Certified Entertainment LLC, Universal Music Publishing Inc., and then Sean Michael Leonard Anderson, which is Big Sean, and Megan Ruth Pete, which is Megan Thee Stallion. Okay. So we're gonna start with the facts. So this is them laying out what's going on, talking about their copyright, their song, all that. They're kind of setting the scene, okay? So in 2012, plaintiffs authored the song Crazy, the copyrighted work, and have publicly and widely distributed the copyrighted work in numerous ways. So anytime I say the copyrighted work, they're talking about their song Crazy. For example, plaintiffs have distributed the copyrighted work through the music platform Reverb Nation, where the copyrighted work has been available to more than 2.8 million artists and consumers worldwide, and record labels and managers who have had access to listen to the song. In 2015, the copyrighted work was ranked #1 in Detroit on Reverb Nation. In addition, plaintiffs distributed thousands of copies of the copyrighted work in CD format in the greater Detroit area. Moreover, beginning in 2012, plaintiffs publicly performed the copyrighted work in numerous clubs in the greater Detroit area. The copyrighted work continues to be available at the following Reverb Nation URL, where it is referenced as Go Crazy. The copyrighted work is an original work of authorship and is particularly unique as a result of its catchy chorus or hook the centerpiece of the copyrighted work. The chorus of the copyrighted work is highly artistic and original. On February 14, 2022, plaintiffs obtained a certificate of registration for the copyrighted work from the United States Copyright Office, a copy of which is attached hereto. Okay, so they came out with this song in 2012. They did not register it as a copyright or get it registered as a copyright until 2022, until this year. That right there is a problem. And it's a problem that a lot of artists have, a lot of new business owners, anyone like that, right? Any type of creatives have this problem where they come out with this amazing work, either it's work or they start this amazing business, and they don't legally protect themselves. And a lot of times it's because we simply don't know, right? You don't know what you don't know. And so that's a huge problem. And the reason I say that's a huge problem is because you can't file a lawsuit without that copyright registration. And even once you get that copyright registration, if you didn't register your copyright within a certain time frame, you missed out on certain money that you could have got in a lawsuit. So for example, if you get your registered trademark before the infringement happens, or like I believe it's either 3 months after the work is published or before the infringement happened. I always mess that up, but you get statutory damages of up to $150,000. Statutory damages is basically money that you don't have to prove really. It's like you get it by law, right? So it's damages you don't have to prove, you get by law. Whereas the other type of damages that you get, you have to prove those. So you have to prove that you lost this money. I hope that makes sense. I have a hard time explaining stuff to people in layman's terms, but I'm working on it, okay? I'm working on it through this YouTube channel. So basically, because they waited so long to get their copyright, they are gonna miss out on extra money that they could have gotten a little bit easier if they win this lawsuit, right? But it is good that they got the registration. Another thing is they probably waited so long to file this lawsuit because they didn't have the registration. That's probably why they waited, because the infringement occurred in 2022. I mean, in 2020 is when the infringement occurred. That's when the other Big Sean and Megan Thee Stallion came out with the song originally. They're now suing in 2022. So 2 years later, or almost 2 years later, now they're suing because they just got the registration. That's what I'm assuming is what was the holdup. So now we're gonna go into the defendant's unlawful activities. What they're claiming is Megan Thee Stallion and Big Sean's unlawful activities. On November 20th, 2020, the defendants Pete, 300 Entertainment, and 1501 released the album Good News. So again, Pete is Megan Thee Stallion, 300 Entertainment, and 1501 released the album Good News. So I'm assuming that's Megan Thee Stallion's album. I don't really listen to like her music that's not on the radio, so bear with me. The album Good News contains the hit song Go Crazy. The song Go Crazy is referred to herein as the infringing work because it is an unlawful derivative of the copyrighted work, infringing both the composition rights and sound recordings, infringing both the composition rights and sound recording rights of the copyrighted work. The infringing work was created by Pete and others, including Anderson, who is featured on the infringing work and credited as a writer of the infringing work. So basically, Megan Thee Stallion, it's her album, the song came out on her album, and then Big Sean is featured on the album, and he's also listed as a writer of the work. The infringing work is strikingly similar to the copyrighted work. The titles of the infringing work and the copyrighted work are strikingly similar. The chorus of the two songs is strikingly similar. The wording of the chorus of the two songs is nearly identical. The timing is nearly identical. The melodic sequence is nearly identical. The harmonic sequence is nearly identical. The tonal sequence is nearly identical. The use of reverb is nearly identical. The use of cadence is nearly identical. An average lay observer would recognize the infringing work as having been appropriated from the copyrighted work because the striking similarity between the two compositions and the way in which they are performed. Indeed, the infringing work is so strikingly similar to the copyrighted work as to preclude the possibility of independent creation. Plaintiffs' wide dissemination of the copyrighted work has made it readily available on the market. The dissemination of the music in the music industry has changed drastically in the last 2 decades as consumers no longer access their music through radio stations and record stores, as they instead access music through their computers and smartphones, where music is readily available on platforms like YouTube and Reverb Nation. Prior to the creation of the infringing work, the copyrighted work was available on both YouTube and Reverb Nation. So basically they're saying our work, because we put it out there so much, it was available on so many in so many areas, and nowadays people consume music on apps like Reverb Nation and on YouTube, and so that's how our music is consumed, and we put it out there. So our music was out there, our music was consumed. The defendants probably heard our music, or they had access to our music because we put it out there just like all other music artists do these days. In addition to availability on internet platforms, plaintiffs distributed thousands of physical copies of CDs featuring the copyrighted work, all prior to the creation of the infringing work. Furthermore, prior to the creation of the infringing work, plaintiffs performed the copyrighted work publicly in clubs and bars. In addition, defendants each had access to the copyrighted work through Anderson. So, having access to copyrighted work is a requirement for copyright infringement. So you can't say someone copied you if they never saw your work. So they're trying to basically paint the picture and say, okay, this is how they could have seen the work. Remember, Anderson is Big Sean. Big Sean is from Detroit. So that's why they said the defendants also had access to the copyrighted work through Big Sean, because he's from Detroit, he heard these songs, and he's on the song. Prior to the creation of the infringing work, Anderson and plaintiffs resided in West Detroit, where the copyrighted work was publicly performed by plaintiffs in West Detroit hip-hop clubs and bars frequented by Anderson. Anderson had further access to the copyrighted work, given the copyrighted work's #1 ranking on the Detroit charts at Reverb Nation in 2015. The sale of thousands of physical copies of CDs featuring the copyrighted work on the streets of West Detroit and the parking lots of hip-hop clubs in West Detroit frequented by Anderson provide further access to the copyrighted work to defendants. Due to the striking similarity between the infringing work and the copyrighted work, the wide dissemination for the copyrighted work, and the access of the copyrighted work by Anderson, defendants each had a reasonable opportunity to hear plaintiffs' copyrighted work prior to the creation of the infringing work. In addition to the striking similarities, there are substantial similarities between the copyrighted work and the infringing work. Defendants have copied music and lyrics which, taken together, are highly original and engaging. Indeed, defendants are reproducing, distributing, publicly displaying, and/or publicly performing the very heart of the copyrighted work, its chorus and hook. The originality, uniqueness, and the catchiness of the copy elements is such that an ordinary person of reasonable attentiveness would, upon listening to both, conclude that defendants have unlawfully appropriated plaintiff's protectable expression. So basically they're saying, like I said, all the defendants had access to the music because Big Sean had access to the music because he went to the same clubs as us in Detroit, or he went to the same clubs that our music was playing in Detroit. He had access, he brought the song to them, and that's how they copied our work. So now we're gonna move down a little bit more. So, okay, on March 31st, 2022, plaintiffs caused a letter to be sent to defendants in order to put the defendants on formal notice of plaintiff's objection to the defendant's unauthorized and infringing reproduction, publication, promotion, distribution, license, public display, public performance, sale, and exploitation of the copyrighted work. The letter also, in good faith, sought to amicably resolve the issue of defendants' continuing infringement in effort to avoid the need for plaintiffs to seek assistance from the court to enforce their lawful rights afforded by Congress under the Copyright Act. Since being placed on notice of the infringing conduct, defendants have continued their willful and reckless disregard to the exclusive rights belonging to plaintiffs, forcing plaintiffs to initiate this lawsuit. So remember, the song came out in November of 2020, and they waited all the way until March 31st, 2022 to send a cease and desist letter. Now, I understand that they wanted to get that the copyright registration before they filed the lawsuit, but I don't understand why they didn't just send the cease and desist letter, because they had the proof that the song was theirs, and they had to file the copyright registration regardless and wait until it got registered regardless. So I would have earlier on sent the cease and desist letter so that maybe it would have lessened the damage, right? It would have mitigated the damage. Maybe Big Sean and Megan Thee Stallion would have stopped playing the song, or maybe not. They probably wouldn't have, let's be honest. But you never know. I probably would have reached out sooner, but at least they reached out, right? So they sent the cease and desist letter, told them to stop infringing on the work, and I'm assuming they didn't stop infringing because it's still on YouTube, and then they initiated this lawsuit. So let's talk about what they're asking for. So we'll go to the prayer for relief, which is basically what are they asking for. So plaintiffs demand judgment as follows: a declaration that defendants have infringed plaintiffs' copyrights under the Copyright Act. A declaration that, so they want the courts to say, you infringed our copyright. A declaration that such infringement is willful, and accounting of all revenue earned by defendants during the period in which it reproduced, distributed, publicly performed, or displayed the copyrighted work, or any portion or derivation of the copyrighted work. Awarding plaintiff all gains, profits, property, and advantages obtained or derived by defendants from their acts of copyright infringement. Awarding plaintiffs such exemplary and punitive damages as the court finds appropriate to deter any future infringement. Awarding plaintiffs interest, including prejudgment interest on the foregoing sums. Permanently enjoining defendants, their employees, agents, officers, directors, attorneys, successors, affiliates, subsidiaries, and assigns, and all those in active concert and participation with defendant from directly or indirectly infringing plaintiff's copyrights, or continuing to market, offer, sell, dispose, or of license, lease, transfer, public display, advertise, reproduce, develop, or manufacture any work derived or copied from the plaintiff, or to participate or assist in any such activity, and for such other and for further relief as the court may deem just and proper. Basically, they saying they want the courts to say they infringed on our copyright. They want everybody to stop infringing on their copyright. So they want Megan Thee Stallion, Big Sean, all those other companies, and any and everybody who works for them to not sell, dispose, license, lease, or none of that of the copyrighted work. So they just want it to all stop. And then of course they want damages, so they want money. And it doesn't say how much money, but they want money. So that is the end of this lawsuit. So again, I want you guys to tell me what you think. Go listen to the 2 songs, leave a comment and say, yeah, I think they copied, or, oh, remember, okay, if you guys watched my last video, I did the whole copy or coincidence. Tell me if you think it's a copy or if it's a coincidence. So do you think that Megan Thee Stallion and Big Sean copied the other song, or do you think it's just a coincidence and the 2 songs just sound alike? So go listen to those songs and tell me what you think, because y'all, I don't know. And what is the lesson for today? Oh, the lesson for today is if you are a creative entrepreneur, if you're creating, if you're making music, if you're making videos, or if you are making songs, or if you're a creative entrepreneur creating any type of content that you potentially think someone might copy, or that you want to be able to sue someone over, make sure you get a copyright, and you want to get the copyright as early as possible. So what I recommend is to get the copyright before you put the work out into the world, because once you put the work out into the world, that gives the opportunity for someone to infringe on it, causing you issues. So you want to get the copyright registered as soon as possible, so that when you do sue someone, you are able to sue for all of the damages you can possibly get. You don't want to leave no money on the table, baby, okay? You want to get all that money. So get your copyright as soon as possible. If you guys enjoyed this video, make sure you guys leave a comment, let me know how great it was. Let me know ways that we can improve these videos because it's definitely something new for me. Also, if you guys have any questions about copyrights or trademarks, you can leave those in the comments as well. General questions only, because I can't give you guys any legal advice because I'm not your attorney, and this is for educational purposes only. Make sure you read the disclaimer in the in the description box, and I will see you guys in the next video. Oh, and don't forget to let me know if it's a copy or a coincidence in the comments. Have a good one. Bye.